You've probably heard analysts condemn the recent indictment of former FBI Director James Comey for a variety of reasons. And you may have heard reports that prosecutors in the Eastern District of Virginia recommended to the newly appointed U.S. Attorney that she not seek charges against Comey because there was no probable cause to believe he committed a crime. In this video, I'll explain why prosecutors likely believed there was no probable cause for this indictment due to something called the literal truth doctrine. I'm starting this channel after more than 30 years as a federal prosecutor to offer you an insider's view into our American legal system and to do it through straightforward, rule of law analysis of real cases. On September 25th, a federal grand jury in the Eastern District of Virginia indicted former FBI Director James Comey. The newly appointed U.S. Attorney in the Eastern District of Virginia sought charges against Comey even though the prosecutors in her very own office reportedly recommended against those charges. The first count of the Comey indictment charges him with making a false statement during his testimony before the Senate Judiciary Committee in September of 2020. One of the elements of the offense the U.S. Attorney will have to prove beyond a reasonable doubt is that Comey's statement was false. Prosecutors often face a significant challenge proving that a statement is false. That is because of the so-called literal truth doctrine. The Supreme Court established this doctrine in a case called Bronston v. United States. And lower courts covering Virginia, where Comey is charged, apply this doctrine to false statement prosecutions such as the Comey case. The core idea is simple. If an answer to a question is literally true, it can't form the basis of a prosecution even if it's evasive. Based on case law in the Fourth Circuit, including a case called United States v. Good, it's likely that the indictment against Comey will be dismissed before the case ever gets to trial. In Bronston, the Supreme Court put the burden on the questioner to follow up with additional questions to clarify any non-responsive answers. In Bronston, the Supreme Court said, any special problems arising from the literally true but unresponsive answer are to be remedied through the questioner's acuity and not by a federal prosecution. Let's look at the indictment. Count 1 of the indictment alleges that Comey made a materially false statement in a matter within the jurisdiction of the legislative branch of the government of the United States by falsely stating to a U.S. Senator during a Senate Judiciary Committee hearing that he, James B. Comey Jr., had not, quote, authorized someone else at the FBI to be an anonymous source in news reports, end of quote, regarding an FBI investigation concerning Person 1. Notice that the indictment places the alleged false statement in quotation marks. As you'll see shortly, Comey never made the statement that the indictment alleges he made. Here's the relevant exchange between Comey and Senator Ted Cruz from that hearing. I've attached a link to the video of the actual testimony in the case if you want to watch it yourself, but I'm using a transcript here to save time. Senator Cruz summarized some of Comey's former testimony before the Senate, and then concluded by asking him this question. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth? Comey responded, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Senator Cruz follows up. So your testimony is you've never authorized anyone to leak, and Mr. McCabe, when, if he says contrary, is not telling the truth. Is that correct? Comey responds, again, I'm not going to characterize Andy's testimony, but mine is the same today. When we simplify the exchange between Senator Cruz and Comey, it's apparent that Senator Cruz only asked two questions. Question number 1, who's telling the truth? A direct answer to that question would have required Comey to say either, I'm telling the truth, or McCabe is telling the truth. But Comey didn't respond by saying who was telling the truth. Comey stated only, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Comey didn't characterize McCabe's testimony as either a lie or the truth, and he stated he could only speak to his own testimony. And Comey's statement, I stand by the testimony you summarized, doesn't characterize the statement as a truth or a lie. Comey's statement that he stands by his prior testimony only indicates that he stands by it. It doesn't indicate necessarily that the testimony was truthful, because one can stand by testimony even if it wasn't true. Let's turn to the second question Senator Cruz asked Comey. That question was, and Mr. McCabe, when, if he says contrary, is not telling the truth, is that correct? A direct answer to this question would have required Comey to say either, correct, McCabe is not telling the truth, or Incorrect. McCabe is telling the truth. But Comey didn't respond by indicating who was telling the truth. He responded by saying that he's not going to characterize McCabe's testimony, and that that is, Comey's testimony is the same today. Comey's statement that his testimony is the same today doesn't necessarily mean that he's vouching for its truthfulness, because testimony can be repeated even though it wasn't truthful the first time it was given. So contrary to the allegation in the indictment that Comey made the statement included in quotation marks, he never made that statement during his 2020 testimony. He was never even asked a question that would have elicited that response. My conclusion that there was no probable cause to seek the indictment and that the indictment will fail is consistent with news reporting indicating that the U.S. Attorney received a declination memo from career prosecutors before she sought the indictment. Those news reports claim the U.S. Attorney was told there was no probable cause to seek the indictment before she sought it. A declination memo in a U.S. Attorney's office is an internal document explaining why prosecutors believe charges should not be filed. Now let's take a look at Count 2. Count 2 charges obstruction of a congressional proceeding under 18 U.S.C. Section 1505. The indictment alleges that Comey, quote, did corruptly endeavor to influence, obstruct, and impede the due and proper exercise of the power of inquiry under which an investigation was being had before the Senate Judiciary Committee by making false and misleading statements before that committee. Although Count 2 alleges that Comey endeavored to obstruct the committee's investigation by making false statements, it doesn't identify any false statements. The vague way that this indictment is charged means that Comey and his lawyers have no way to prepare their defense because they have no idea what the alleged false statements are. Presumably, the U.S. Attorney will rely on the same false statement charged in Count 1, but unless the U.S. Attorney can identify additional false statements or acts committed by Comey in an attempt to obstruct the investigation, this Count 2 will fail, and it's likely Comey's lawyers will file a motion for what's called a bill of particulars. If granted by the court, and in this case it seems highly likely it will be granted given the vague nature of the allegations in the indictment, then the government will have to specify what those additional false statements that Comey allegedly made were. And once those statements are identified, Comey's lawyers will have an opportunity to file an additional motion, and unless additional statements are identified that don't suffer from the same problem as the statement charged in Count 1, then Comey's lawyers will no doubt succeed in having the entire indictment dismissed. Given my 30 years as a federal prosecutor, including involvement in false statement cases, I'm confident that the declination memo provided to the U.S. Attorney by career prosecutors indicated that this case will fail because of the literal truth doctrine. If you found this analysis helpful, please subscribe to this channel so you don't miss future videos. And if there's a case or legal issue you'd like me to cover, leave a comment. I'm always open to your ideas.